Hey there guys, welcome to my first video on criminal law. In particular, we're going to look at theft today. This video goes out to Mighty Mouse, who's been really supportive of the channel, and also goes to University of Huddersfield, so I'm a bit biased. I think the key thing with theft is that there's 5 elements that we're going to look at. And really, whether it's an essay question or a problem question, you can't really consider yourself finished until you've looked at all 5 elements in some detail. Now, most of the time theft comes up as a problem question, so that's going to be our focus today. But we'll also try and criticize some of those 5 elements as we go through, so that if you are working on an essay question, then hopefully that'll give you lots of things to think about and also to look at as well, and do some research in academic journals, etc. Right, let's get started. As I mentioned, when it comes to theft, there are 5 key elements, and we get those elements from the definition of theft that comes from the Theft Act 1968. In particular, Section 1.1, which I've blown up to size here, gives us the full definition. And the 5 key elements are an element of dishonesty, appropriation, property, belonging to another, and then the intention to permanently deprive. Now, if you're going through those 5 elements, you can go through them in any order. A lot of people go through them as the definition does it, so dishonest, appropriation, property. What I'm going to do for this essay is go through the actus reus first, the elements that can constitute the active or physical part of the crime of theft, and then move on later to the mens rea, or the mental elements that constitute theft. So if we start with the first actus reus, we can look at appropriation, which comes from section 3. Now, when the Commission was first designing the Theft Act, they thought of using the word conversion instead, but they thought that people didn't really know what the word conversion really meant. Also, it has quite a narrow definition compared to appropriation as well. So in the end, they decided to go for appropriation because people would understand it, and it's broad enough to capture what they wanted to say. Now, when we're talking about appropriation, it's appropriation of a right, not all rights. So in Morris, what happened was a guy went to the supermarket, swapped the prices around on a couple of items, and ended up paying less for something that should have cost more. So he did pay for the product in the end, he just didn't pay the full price. So he didn't appropriate all of the supermarket's rights in the product, but because he did appropriate at least a right, even if that was only 1 penny, for example, that's still enough to constitute appropriation for the purposes of theft. Now, one of the most controversial areas in terms of theft and appropriation in particular is it's possible to appropriate something even if you do have consent or the title. And this area of case law first started with Gomez in 1993, where a manager of an electronics store signed off on checks that the defendant claimed were cleared by the bank. Now, it turns out that the defendant was in on a sort of scheme the whole time. The checks didn't clear in the end, and he was convicted of theft. The idea behind this, though, and the reason that it's controversial, is because the defendant did actually have the manager's sign off on this, and so he did have the consent of the manager when he committed the act. Even if that was fraudulently claimed, this would be more of a different offence compared to theft. So the fact that he was convicted of theft, and in particular appropriating the goods even with the consent, was quite controversial. Now, this issue came up again in the year 2000 with Hinks, that I've put at the bottom of that slide, and many people thought that this was a good opportunity for the House of Lords, as it was at the time, to reverse the case law in Gomez and return to sort of a normal way of approaching the law. But in fact, what happened in Hinks, where a woman basically not tricked an old person into giving her £50,000, but even though the person was of limited mental intelligence, did consent to give her the £50,000, this was still considered theft. So she had the consent of the person, and it was held that this person did have the competence to make a gift. But she was still convicted of theft. And again, this was a very controversial decision because even though what she did was clearly wrong, it was questionable whether it really amounted to theft, given that it was essentially a gift. And so these decisions have been really criticised over the years, but the case law hasn't changed since 2000. And the problem with this is that it almost takes away appropriation as part of the theft. It reduces the importance of the actus reus. And so there's maybe too much focus now on the mens rea or the mental element, because the actus reus is so broad in the light of Gomez and Hinks. Now, Section 3 of the Theft Act also talks about keeping or dealing with the property as the owner. So essentially, when you appropriate or take something, you're dealing with it as if you're the owner, and it can be keeping or dealing. So those are alternatives. Now, theft is a finite act, and this was decided in Atakpu, 1994. And Justice Ward said that made this claim about theft, and it's really important. So what happened in this case was that the defendants went over to Germany, hired a car with false papers, brought the car back to the United Kingdom and tried to sell it. Now, they were stopped at the border, and they tried to convict the people at Atakpu of theft in the United Kingdom rather than in Germany. And the courts decided that because the appropriation took place in Germany, so the taking place took there, it wasn't possible to convict them of it when they got back to Dover in the UK. And this is really important. Glanville Williams puts it really well in a journal article from 1978. He says, otherwise it would be possible to convict a thief of theft of a silver teapot every time he uses it to make tea. So if you were convicting someone every time they acted as if they were the owner rather than every time they appropriated something, it would create a sort of ridiculous area of the law where a person could be convicted of theft several times for only stealing one thing. Section 3.2 also deals with a bona fide purchaser. This is mentioned in Wheeler 1990. And in this case, there's an obligation to report if you find out the goods are stolen. So if you do receive something and you buy something and you think that it has good title, then you aren't guilty of theft. But if you do later discover that those goods were in fact stolen, you're then under an obligation to report that. And if you fail to do so, you can then be convicted of an offence. So let's move on. So property also forms part of the actus reus. This is defined in section 4. It's a relatively straightforward and obvious definition, real or personal property, but let's have a think about things in action and other intangible property. So things in action are things that are not necessarily physical, but things that are being used on a constant basis. So a good example would be bank accounts, which we can look at the Cone case for from 1979. And other intangible property as well. Quotas would be another obvious example. Attorney General of Hong Kong and Chan Nai-kung from 1987. So you can see their quotas are not a physical object. They're not something that you can lay your hands on, but it's still possible for them to be stolen. So you can think of other things that could be stolen as well, such as intellectual property rights and things like that. The final part of the actus reus is that it has to belong to another person, and this is an element of possession or control as defined in section 5.1. And again, it sounds like it's relatively obvious. Does the property which was taken belong to another person? In most cases, it's straightforward, but in Marshall, a 1998 case, there was a ticket touter on the London Underground. And the idea was that, well, once London Underground has issued the tickets, they're no longer belonging to London Underground. They belong to the customer. And if they want to give their ticket to a tout, then that's their decision. And it's not something that London Underground is losing out from. The property at that point doesn't belong to them. The courts actually disagreed in the end and said that essentially it did still belong to London Underground. So a little bit of a controversial decision there, but worth reading the case to see how the court got round that. Turner number 2 from 1971, again, another slightly controversial decision, perhaps less so this time. Here, someone used their spare keys to effectively steal their own car from a repair shop without paying for it. So they'd had the car repaired, they were due to pick it up the next day, but they went at night while the car was parked outside the repair shop and essentially stole their own car by using a spare set of keys. The court convicted this person by saying that at the time the car belonged to the repair shop because the bill hadn't been paid. So that decision is probably a little bit more fairer, and it's easier to see how the courts could stretch the definition of belonging to another so that it could be construed that that was theft, even though the person was stealing their own car. Section 5.3 deals with property received for a particular purpose. So if you receive property and you're meant to dispose of it in a certain way, so say someone gives you £5 to go and buy lottery tickets from the local shop or something, and you decide to just instead go and spend that on beer, then obviously you're not using the property for the purpose with which you were sort of defined to use it. And so you could be convicted of theft, although that's possibly a bad example because there has to also be a legal or contractual obligation there as well. So you could argue that that would be an oral contract, but most of those cases that come under section 5.3 is where there is an element of using property for a particular purpose as a result of a contractual obligation to do so. So section 5.4 deals with a positive obligation to return property received by mistake to the original owner. And this Attorney General reference case is really interesting. It involved a police officer who had been accidentally paid too much. And she realised that she'd been paid too much, but she didn't say anything. But at the same time, she didn't spend any of the extra money either. Now, the police later found out that she'd been paid too much, asked for the money back, and convicted her of attempted to convict her of theft. She was found guilty, and this conviction was actually upheld because even though she hadn't spent any of the money, what she should have done is as soon as she realized that the property, or in this case the money, did not belong to her, then she should have reported it and made sure it was returned to the police. Let's move on to the mens rea now. Section 2 deals with dishonesty, and this section effectively defines when a person is not dishonest. So when is a person acting honestly? And once we understand that, we can kind of see the flip side of it and understand when a person is acting dishonestly. So 2.1a is the belief that a person has the legal right to deprive the owner of the property. So we've got an example of a case there, relatively straightforward. Belief that the owner would have consented to the appropriation. So for example, if I was sort of at home at my parents' house and the window cleaner came and I didn't have enough cash and I borrowed some money from my mother's purse or something, gave that to the window cleaner, then I'm doing so with the belief that my mother would have consented to the appropriation. So that's an example there. And belief that the owner could not be located by taking reasonable steps. Sylvester 1985 deals with this in a little bit of detail. In particular, it talks about the importance of the context of the situation. So if you see someone dropping a £5 note in a secluded alley, then you're under an obligation to return that, and failure to do so would be theft. However, if it was just £5 that you found lying in the middle of a busy shopping street on a Saturday morning, then you would probably be able to keep that property because it would be impossible to track down the true owner in those circumstances. So context is really important for that section 2.1c. Now, the main test for dishonesty comes from Gouge, and in particular, this is based on a couple of previous cases. Feely from 1973 established an objective test for dishonesty, so what would the reasonable person consider dishonest? And then later in 1978, Bogeln and Williams introduced a subjective test, saying, would the defendant consider it dishonest? And so for a little while, the case law was a little bit confused about this, but in 1982, the courts developed the Gouge test, which combines both elements. Now, I'm not sure if you can see the flow chart on the screen there. Hopefully it shows up okay. But if not, then I'm going to run through it now, and you can sort of follow this when you're doing this in an exam or a coursework question. So the first question to ask at the top there, was the action dishonest according to ordinary standards? So this is the objective element of the test. Would the reasonable person consider the defendant's actions dishonest? If no, then the defendant isn't guilty. If yes, we go on to ask a subsequent question, and this is the subjective element here. Did the defendant realise that reasonable people see that action as dishonest? So what how did the defendant view their own actions is what we're asking here. If it's no, they didn't realise that reasonable people would see their action as dishonest, then again, they're not guilty. But if yes, they did, the defendant did realise that ordinary people would see their actions as dishonest, then that person can be convicted of theft. Now, there's been a number of criticisms of the Gouge test over the years, in particular in relation to Article 7 since the passing of the Human Rights Act 1998. And this is all to do with the certainty of the test. In other words, what one person might see as reasonable might not necessarily be reasonable to another. Definitions of honesty and dishonesty can change between juries. And so this test was challenged in a case called Patney from 2001. I think that's spelt Pattni. But the court basically said that it was compliant with Article 7, and so there wasn't a problem there. However, this hasn't necessarily stopped the criticism of the Gouge test. Having that objective and subjective element can be seen as a good thing because it's a combination of factors before you convict someone. But again, as we've already said, it can lead to uncertainty and potentially also lead to the Robin Hood defence. So if someone was stealing from the rich to give to the poor, the jury might say, okay, well, that might be considered dishonest, but if the defendant thought that they were doing the right thing, then a jury may not convict that person. So a little bit controversial. So the final element of the mens rea is the intention to permanently deprive. This comes under section 6, and it's been given a broad interpretation even before the Theft Act 1968 came in. So you can imagine a number of situations in which there isn't an intention to permanently deprive, but someone could still be convicted of theft in those circumstances. So ransom cases, there isn't an intention to permanently deprive, because if someone pays the £10,000, for example, then the person will be given their precious dog back, for example. And so without the intention to permanently deprive, it was important that that can still be regarded as theft, and that comes from Hall, 1849. Returning the property in a different form we'll look at in a second, but you can look at Richards for that. And pawning as well, again, there might not be an intention to permanently deprive in those circumstances, but clearly pawning someone else's property is wrong, and so it's important to be able to convict someone of theft in those circumstances. Now, section 6.1 talks about intention to permanently deprive for a period, making it equivalent to outright taking. And Volumil is another example there. And this talks about where a company director took money from a safe just to use over the weekend and then return it on Monday morning. But it was considered that even though this was just for the weekend and wouldn't have any effect on business, that was for a period of time that made it equivalent to outright taking. To give you another example, and to link this back to the property coming back in a different form in Richards, you can imagine having a ticket to a gig, and if someone stole that ticket and then went to the gig, came out of the gig at the end and gave you back the ticket, then there isn't an intention to permanently deprive there, because you've got the piece of paper or the ticket back. But the point is that that ticket is now useless because the gig's over and you haven't been able to go. And so we can see that the property is essentially either come back in a different form, or the period for which the person's taken it has made it equivalent to outright taking. In essence, the ticket is now useless, and so despite the fact that there isn't an intention to permanently deprive, it's essentially the same thing, and it's important to be able to still convict someone of theft in those circumstances. And there we have it. Theft is the dishonest appropriation of property belonging to another person with the intention to permanently deprive. And as long as you cover all 5 of those elements in any coursework or exam question, you'll be absolutely fine. Remember, it doesn't matter which order you cover them in, just make sure that you do all 5 of them. Think back to sort of the lecture. There's loads of cases that you can use as you're going through those 5 elements. Definitely include things like the Gouge test. And if you are doing an essay rather than a problem question, think about some of the criticisms that we discussed as well. It doesn't take much of a Google search to find loads of articles as well with criticisms not only of the Gouge test, but things like Hinks for appropriation and other stuff as well. So I'm sure you'll be absolutely fine answering any question on them. Thank you very much for watching. If you enjoyed the video, remember to give it a like, subscribe for more videos. I'm hoping to do more criminal law in the future. And if you have any questions or comments, then please leave those below and I'll make sure to get back to you. Thanks again. Bye.